Namaskar, I am Advocate Saurabh Kunal. Today we are going to discuss how to draft a will, and we will also discuss what are the major mistakes people usually do while drafting a will. So let's first understand what is will, what is the importance of will, how to draft a will, and then finally we will discuss what are the general mistakes committed while drafting a will. So first, what is a will? As per the Indian Succession Act, under section 2H of the Indian Succession Act, a will is defined as an instrument where the testator expresses his intention, the manner with regard to disposal of his assets, movable and immovable, to the beneficiaries. Now, why will are important? As per the records, 50% of the civil cases in the district court are fought between the families, generally over the property dispute. So, if somebody is not writing a will, this is the biggest mistake. Now, we will discuss about the ingredients of a will. First, we need the name, age, proof, and other personal details of the testator. Testator means the person who is going to write his will. Secondly, we also need the name, age, and other personal details of the beneficiaries. And thirdly, the executors. Here it is very important to note that the certificate name, the official name of the person must be maintained in the will. For example, if somebody is Subodh Kumar Gupta and if he is writing his will by the name of Subodh Gupta, then his will be invalid. Now, how to draft a will? First, we need all the ingredients of the will, the details of the testator, the beneficiaries, and the executor. Apart from that, we also need the details of assets. Then it is advisable, even though a will can be written by the person himself, but it is advisable that he must consult an advocate before writing his will. Now, after that, the testator must sign the details of the will in presence of two independent witnesses. And to avoid, the fourth step is to avoid any kind of litigation after the death or any kind of litigation over the property dispute. It is advisable that the will should be registered before the sub-registrar office. Now, what are the mistakes generally people commit while writing a will? First and foremost is mistake in their name. Generally, people mistake while writing their official name, as we take the earlier example where Subodh Kumar Gupta has written his will in the name of Subodh Gupta. So this is a mistake. And the same principle lies in the case of beneficiaries also and executor also. Next is when you are putting witnesses, the witnesses must be independent, means they should not be a party to the will. So obviously they should be independent. Thirdly, people after writing the will, they forget to keep a original copy. That is also a mistake. One must keep a original copy of the will. Then other mistake, people usually forget to uh, mention their debt. So it again create disputes. People also forget to mention the details. They do not specify sometimes their assets, movable. Sometimes if they know the immovable property, they forget to mention the movable, the assets. So it is also required to mention. Sometimes it is also a mistake that they over specify their assets. For example, if somebody is keeping a Honda City car and he has in his will he has said that this Honda City after his death will go to his younger son or older son, elder son. So in the meanwhile, before his death, if he sells his car, then again it will create dispute and confusion in the will. Next issue, you must need to update your will. Means if a will, after writing a will, if a marriage ceremony occurs in the home or if a child is born, you must mention these things. After you need to write your will. Now there is a question, how many times a will can be written? So there is no foundation. You can write as many will as you want, but the last will be the final. And if you have written a will, you can amend it also. You can also write. You must also in the details of while writing a will, you must specify the date. And if you want to alter the previous will, you can specify that in the will dated this and this, you are going to alter it. So in this way you can alter it. You can cancel it altogether. So these are the ways to change it as per the time. But the last will should be the final. And even the Supreme Court in various cases, particularly in Ghamal Amal versus T. Raju, has categorically said that intention of the testator must be clarified before confusing the meaning of the will. So obviously the meaning is very meaning what the testator wants to what is the intention of the testator regarding the disposal of his assets, that is very much required. So these are the essential things about the will. So if you like my video, please like, comment and share. And if you have not subscribed my channel, please subscribe. Thank you so much for watching this video.